In the United States District Court for the Northern District of Texas, Dallas Division, Eunice Lofty versus David Holman, Officer Smith, and City of Forney, case number 3-22-CV-0922-S. Defendants' reply to plaintiff's response to their 12B5 motion to dismiss for insufficient process and brief in support. Come now, defendants David Holman, Officer Smith, and City of Forney. Hereto Forney defendants, and file their reply to plaintiff's response to their motion to dismiss for insufficient process and brief in support as follows. 1. Plaintiff's reply underscores his deficient service. Service of process upon a defendant in a federal lawsuit is not so simple as delivering a Christmas card. Federal law sets forth requirements for plaintiffs, even those proceeding pro se, that are meticulous. Plaintiff, or more precisely, inept, self-professed process server Jose DeCastro wholly failed herein. The plaintiff's response in opposition to defendant's motion to dismiss per Rule FRCP 12B5, Docket 13, hereinafter, quote, response, crows that, quote, summonses were executed upon the defendants and proof of service was filed on 7/1/22. See docket number 8 and 9. End quote. He remains incorrect. Plaintiff does not, because he cannot, claim DeCastro personally served Officer Holman, Corporal Smith, or any authorized agent for the city. The video clearly confirms otherwise. Rather, plaintiff incorrectly avers that, quote, actual notice is somehow sufficient. It is not. Dismissal should follow. 2. Purported, quote, actual notice is not sufficient to cure failed service. Unlike horseshoes or hand grenades, quote, close does not count when it comes to service of a federal summons. Here, plaintiff pins his hopes on tossed summonses which all missed the mark. Instead of properly serving the two police officers and an authorized City of Forney representative, YouTube sensationalist DeCastro paraded into the police department and City Hall and dropped off summonses to persons who were not authorized to receive summonses. Plaintiff now desperately clings to the mistaken belief that purported, quote, actual notice of the lawsuit is sufficient to satisfy service rules. Even his garbled recitation of case law does not support such a proposition. Quote, due process under the United States Constitution requires that before a court may exercise personal jurisdiction over a defendant, there must be more than notice to the defendant and a constitutionally sufficient relationship between the defendant and the forum. Weingarner v. Cinemark, USA. Simply put, quote, defendant's actual notice of the litigation is insufficient to satisfy Rule 4's requirements. Way versus Mueller Brass Company. Plaintiff's reliance on, quote, actual notice as a substitute for proper service is simply misplaced. He offers nothing to prevent this court from concluding that none of the Forney defendants were correctly served with summons, under even the most broad construction of Rule 4. 4. Plaintiff does not show good cause for his failure to serve. Plaintiff chides that, quote, defendants have a fundamental misapprehension of the purpose for the rules of service per FRCP 4. Continuing, quote, plaintiff believes that service was accomplished in good faith and fairness and in consideration of the Fifth Circuit's broad construing of the provisions of Rule 4, end quote. He urges that, quote, in light of the attempted service and his pro se status, plaintiff should be provided with an additional opportunity to serve the defendants, end quote. Plaintiff has failed to show any good cause for his failure to properly effectuate service, and thus his request should be denied. Quote, Federal Rule 4M permits dismissal of a suit if the plaintiff fails to serve a defendant within 90 days of filing, but provides that, quote, if the plaintiff shows good cause for the failure, the court shall extend the time for service for an appropriate period, end quote. Laham versus Nationwide Provider. Quote, good cause under Rule 4 requires at least as much as would be required to show excusable neglect, as to which simple inadvertence or mistake of counsel or ignorance of the rules usually does not suffice, end quote. The right of self-representation does not exempt a party from compliance with relevant rules of procedural and substantive law. Ferretta versus California. Importantly, pro se litigants are not absolved from compliance with the requirements of Rule 4. System Sign versus U.S. Department of Justice. See also Kirsch versus DeRoser. Plaintiffs entreaty to the court for more opportunity at service rings particularly hollow. On April 26, 2022, plaintiff filed his pro se complaint and paid the $402 filing fee. Thus, plaintiff was responsible for effecting service of process on all defendants by July 25, 2022. Plaintiff was expressly, quote, placed on notice that service of process must be accomplished within 90 days of filing, unless good cause is shown, or this case may be dismissed. There were multiple opportunities to serve these defendants, yet plaintiff squandered his chances to do so by relying on contumacious, quote, clerk of the court, DeCastro's single, albeit bungled, effort to effectuate service. Plaintiff should not be rewarded for his, or really DeCastro's, desultory disregard of the rules regarding service. Equally telling is that since the filing of defendant's motion to dismiss for insufficient process and brief in support, plaintiff and his ally DeCastro have done nothing to remedy their defective service. In a giddy rush to solicit internet comments and post the service gone awry video, the concern for complying with the federal rules of procedure fell to the wayside. Plaintiff's assertion of, quote, acting in good faith and fairness, end quote, is further rebuked by the spurious allegations underlying this litigation. Recall that he has sued 2 City of Forney police officers along with the City of Forney arising a road rage incident between plaintiff and another driver occurring November 10, 2021. Today, August 12, 2022, a jury unanimously and swiftly convicted plaintiff of the criminal offense underlying this road rage incident and imposed maximum sentence. A copy of the judgment after jury verdict in this case, styled State of Texas versus Eunice Lofty, case number 2101672 in the Municipal Court of Record number 1 of City of Forney, Texas, is attached hereto as Exhibit number 1. Plaintiff was required to show exhaustible neglect, as well as establish good faith and a reasonable basis for not serving the summons and complaint within the time allowed by the rules. System Signs Supplies vs. U.S. Department of Justice. Plaintiff does none of this. Dismissal is certainly appropriate at this juncture. Wherefore, premises considered, defendants David Holman, Officer Smith, and City of Forney pray that the court grant their motion to dismiss for insufficient process, that is, dismiss plaintiff's claims and pleas for damages, and they have such other relief at law or in equity to which it may show themselves entitled. Respectfully submitted by Robert J. Davis. State Bar Number 055-43500. Matthews, Shields, Knott, Eden, Davis, and Beanland, LLP. Attorney for defendants David Holman, Officer Smith, and City of Forney. Certificate of Service. I hereby certify that on August 12, 2022, I electronically filed the foregoing document with the clerk of the court for the Northern District using the electronic case filing system of the court. The electronic case filing system sent a, quote, notice of electronic filing to the following attorneys of record who have consented in writing to accept this notice as service of this document by electronic means. None. Additionally, a copy of the foregoing was mailed to the pro se plaintiff by certificate of mail, return receipt requested, signed Robert J. Davis. Exhibit 1, referenced earlier in this document. Case number 2101672, State of Texas versus Eunice Lofty in the Municipal Court of Record number 1, City of Forney, Kaufman County, Texas. Judgment after jury verdict. On this, the 12th day of August 2022, the defendant in the above numbered and entitled case appeared in person and entered a plea of not guilty and demanded a jury trial, and the jury, having heard the evidence and arguments, found the defendant guilty of the offense of change lane when unsafe, and the jury assessed a fine of $200. It is therefore ordered and adjudged by the court that the State of Texas, for the use and benefit of the City of Forney, Texas, does have and recover from the defendant the fine in the amount of $200 plus any and all costs required to be paid, which as of this date are $339. Having determined that the defendant does not have sufficient resources or income to immediately pay all or part of the fine and costs, it is hereby ordered that the defendant pay the fine and costs at designated intervals. See attached installment agreement order incorporated as part of this judgment. The defendant is hereby ordered to pay the fine and costs at designated intervals. See attached installment order incorporated as part of judgment. This ends the reading of defendant's reply to plaintiff's response to their 12b-5 motion to dismiss for insufficient process and brief in support. Read by Coded Friend 001. Failed, 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 failed.